So impediments beyond control is a very important concept. It's a defense to non-performance of a contract. It's an excuse. The problem with impediment beyond control, as we kind of saw when we talked about it, is that sometimes it may be hard to approve. You've got to go through certain steps to establish impediment beyond control. And what you are really asking a court to do in those circumstances where you're denying liability is to say, Judge, we didn't live up to our obligations under the contract, but we had a good excuse. We had a good reason why that happened. So that is what we call an extra contractual remedy. It's a remedy outside of the contract. What commercial companies have determined is that it is much better to include in the contract those elements that would justify non-performance. And we do this through the imposition of what's called a force majeure clause. Lawyers will frequently advise their clients to put this clause, force majeure means superior force, into the contract itself. And what it is a contract clause in which it states the circumstances under which a party is justified for failing to perform. So things like a war, or blockade, or fire, or strike, or hurricane, or tornado, or any other act of God, we include those into the contract. This is a much preferred remedy because your defense is not, yeah, we breached the contract, but we had a good reason why. Instead, your defense will now be, Judge, we were doing what the contract permitted us to do, which is to say we failed to perform, but that was a contractual right that we had in the contract. So it is not an extra contractual remedy, but a contractual remedy, meaning it's found within the scope of the contract. It's built into the contract. We don't have to look for legal justification. Instead, we only look to, was the thing that happened included in the contract? So in most every international sales contract, the parties will include the force majeure clause. And I'll upload one to D2L to make sure that you can look at it. But the advantage of the force majeure clause, and this is what you should know, is that by using force majeure, the party that does not perform is actually complying with the contract. And therefore, it's not a failure to perform. They don't breach the contract because they're doing what the contract permits them to do. So rather than measuring legal justification, we simply look at, was this a breach of the contract or not? And if we include those terms in our contract, then we don't have to make an excuse. Courts do not like to release parties from liability on a contract based on an excuse. Therefore, we use this contractual reason why we failed to perform. We met our obligations under the contract because the contract said under certain circumstances we don't have to perform. Government approval is another type of a special type of force majeure clause. Companies certainly today in today's environment recognize that permission is needed to transact businesses across national borders. And if you sign a contract with a company in another country and then say the United States puts sanctions on that other company, what those sanctions are is it says you can't go through the contract. You cannot fulfill your contract. You cannot perform your contract. And so in those situations where government approval might be necessary, companies will include a clause in the contract that allows them, again, to avoid performance by citing a contractual obligation. The alternative to a force majeure clause is to use that impediment beyond control language, and that's not a good alternative. That's not the best alternative. It's there if you need it. If for whatever reason you didn't include a force majeure clause, you're not automatically liable. However, rather than having to prove up this legal justification, this legal excuse, instead I can just rely on this contractual agreement. By using force majeure, the party that does not perform is complying with the contract and therefore does not breach the contract. In conclusion, what do we learn in this lecture? The law defines damages as the money claimed by or ordered to be paid to a person as compensation for a loss or injury. We said there are 3 components to monetary damages. Make sure you know what those are, and make sure you know how to calculate monetary damages. There'll be some simple questions on your test. And we know that damages can be calculated. That's it, and thanks for listening.